Imagine doing literally everything right. You take every possible precaution, you're as careful as humanly possible, and yet, bam, things go disastrously wrong, and you are still held legally responsible. That is the kind of terrifying but honestly fascinating concept of strict liability in tort law. Welcome to this explainer. Today we're giving you your definitive, highly structured exam blueprint for one of the most famous and, let's be real, trickiest areas of law, the rule in Rylands v. Fletcher. So if you're aiming for top marks in your A-Level Law exam, you are absolutely in the right place. Let's get into it. Okay, here's our agenda for today. We're going to cover 1. The foundations of strict liability, 2. Accumulation and dangerous things, 3. Non-natural use of land, 4. Mischief, escape, and damage, and finally 5. Defenses and remedies. All right, Section 1, Foundations of Strict Liability. To really get Rylands v. Fletcher, you first got to wrap your head around strict liability. Under strict liability, the claimant actually doesn't need to prove the defendant was negligent. Liability can arise even without any fault at all. I mean, think about how dangerous this concept is for defendants. You could be a totally responsible landowner who took perfect care, but if the required elements are met, you are still legally on the hook. It's a true no-fault tort. The whole principle actually stems from the classic 1868 case of Rylands v. Fletcher itself, where a reservoir basically flooded a neighboring mine. But hey, listen up. Here is an absolute piece of exam gold for you regarding damages. A claim under Rylands strictly protects land and property. You absolutely cannot make a claim for personal injury alone under this tort. The courts have made that incredibly clear in recent years, so it's a super essential point to remember for your exams. So how do we actually go about proving this tort? Well, there are 4 essential elements that you must satisfy. Number 1, the defendant must bring something onto the land. 2, it must amount to a non-natural use of the land. 3, the thing must be likely to do mischief if it escapes. And 4, it actually must escape and cause damage. All 4 of these have to be proven. Moving on to Section 2, accumulation and dangerous things. Okay, so the very first rule is that the defendant has to actually bring or accumulate the thing on their land. To ground this, let's look at the frankly fantastic case of Giles v. Walker from 1890. So we've got these pesky thistles and weeds that were just naturally growing on the defendant's land. The wind blows, and the weeds spread onto the claimant's adjoining land, causing damage to their crops. Naturally, the claimant sued, probably thinking they had a slam-dunk strict liability case, right? Well, they completely lost. The court ruled that the defendant had not brought and accumulated those weeds, they were just naturally occurring. So, the absolute crucial point and the legal significance here is this. If a dangerous thing is just naturally present on the land, like weeds or naturally accumulating rainwater, and you didn't actively bring it there yourself, there is zero liability. You have to purposefully accumulate it. Let's head into Section 3, non-natural use of land. Now, this element, non-natural use, is honestly often the hardest for claimants to prove in modern courts. The courts have decided that non-natural literally means extraordinary and unusual. Let's compare 2 major cases to see this in action. In Transco plc v. Stockport NBC, a water pipe that supplied a block of flats leaked and caused a huge embankment to collapse. But the court said, hey, piping domestic water is a perfectly ordinary use of land, so no liability. On the flip side, in Cambridge Water, a leather manufacturer was storing massive quantities of industrial chemicals, which eventually seeped into the soil. Storing giant vats of chemicals is extraordinary, therefore it's a non-natural use. Ordinary domestic use just won't cut it. Let's lock this in really quickly with a summary. For bringing something onto land, your go-to case is Giles v. Walker, which proves that naturally occurring things just don't count. For non-natural use, your absolute key case is Transco, establishing that ordinary, everyday land use limits the scope of Rylands. Pairing these case names with their exact legal principles is exactly how you show the examiner you truly understand the mechanics of the law. All right, Section 4, mischief, escape, and damage. Let's start with the whole concept of an escape by looking at the pretty dramatic facts of Reed v. J. Lyons from 1947. So a munitions inspector was working inside a weapons factory. While she was inside, along with some other employees, an artillery shell violently exploded, causing some really serious injuries. The claimant obviously argued strict liability under Rylands v. Fletcher. But Viscount Simon and the House of Lords completely shut the claim down, and it was all based on this exact definition of an escape. It must be a movement from a place where the defendant has control to a place outside his control. Because that shell exploded inside the factory, the danger never actually left the defendant's property. There was literally no escape from the land, meaning the claim completely failed. And this sets the scene perfectly for a modern and highly tricky case, Stannard v. Gore from 2012. The defendant ran a tire fitting business and was storing roughly 3,000 tires in a totally haphazard manner. A fire breaks out, ignites the tires, and spreads super rapidly, causing massive damage to the claimant's adjoining premises. You look at that and probably think, an escape that caused damage, Rylands absolute applies here.
But here is the strict exam gold trap that catches so many students out. The thing brought onto the land must actually escape. The Court of Appeal ruled that, while the fire escaped, the defendant didn't bring fire onto the land. He brought tires onto the land, and the tires themselves did not escape. Therefore, no Rylands liability. It's an incredibly specific, very strict interpretation.
Let's cement this with another quick summary, this time for elements 3 and 4. Cambridge water is super vital because it actually added the requirement of reasonable foreseeability to the mischief element. The damage must be reasonably foreseeable if the thing escapes. Then you've got Reed v. Lyons defining escape, and Stannard v. Gore proving that the exact thing accumulated must be the thing that actually escapes.
On to our final section, Section 5, Defenses and Remedies. Look, even though this is a tort of strict liability, it is not absolute liability. There are recognized legal shields you can use. You can argue act of a stranger, act of God, like an extreme, totally unforeseeable weather event, statutory authority, consent, or contributory negligence where the claimant is partly at fault. Let's see one of these in action, the act of a stranger defense. This is beautifully illustrated by Perry v. Kendrick's Transport Limited. The defendants parked a bus on their land and totally drained the petrol tank. But then, completely out of their control, a stranger removed the petrol cap and a child threw a match into the tank, igniting the fumes and causing an injury. The court held there was zero liability here. The defendants had a perfectly valid defense because the escape was caused by the unpredictable actions of a third party, a stranger, over whom they had absolutely no control. Right before we wrap up, we really have to look at this vital comparison for your A-level exams. How does Rylands actually compare to standard private nuisance? Well, nuisance is all about ongoing, continuous, indirect interference. Think terrible smells or really loud noises over a long period of time. And it heavily considers the character of the neighborhood. Rylands v. Fletcher, however, is deeply unique. It focuses specifically on isolated, one-off incidents, a single explosion, a single massive flood, where a dangerous thing physically escapes and causes strict physical property damage. And remember, the sole remedy usually awarded in a successful Rylands claim is financial damages to cover the cost of repairing or replacing that destroyed property. Which brings us to a final, slightly provocative thought to really help you secure those top exam marks. You've seen exactly how strict the judges are being lately, by demanding non-natural use in Transco and insisting the specific thing must escape in Stannard v. Gore. The courts are actively narrowing the scope of this tort. Some legal scholars even argue it should just be abolished entirely. So, I'm going to leave you with this to ponder for your essay conclusions. Is the 150-year-old rule in Rylands v. Fletcher destined to just fade away, eventually becoming completely absorbed by the general law of negligence? Use the cases we've covered today to argue your side. Thanks so much for joining me on this explainer, and best of luck with your revision.